list of contract must-haves. But this oversight can make leaving a position a very costly and lengthy endeavour. To look at this more closely, I spoke earlier to Joydeep Hor, Managing Principal with People and Culture Strategies. Joydeep Hor, welcome to the program.
Thank you, Whitney.
Now, is it often the case that high-level executives don't consider an exit strategy when they're signing a new contract?
It is very common, and naturally the excitement of starting a new role and the challenges that are associated with that will often lead to the focus being more on the opportunities that are presented with that particular role and engagement. And it's the last thing, not just for the employer, but also for the employee to be thinking about what's going to happen when things sour, and that's usually the exit strategy piece.
So has it always been the case, or as economic climates change, does that become more and more of an issue?
I think what we see is that some executives who've been through some difficult times, perhaps in previous organisations, will have it more at the forefront of their mind. What we're also seeing in this particular economic climate is that executives are mindful that as much excitement as there might be at the time of engagement, the reality is that the challenge is there, and the likelihood of longevity is not necessarily quite what it was perhaps a decade ago.
Is there an element of exiting the company that's so far down the track that it's like, let's think about that later?
Yeah, I think the psychology of it's very interesting, because it's fundamentally requiring the executive to shift their headspace to the assumptions that they won't be successful, or that there will be some performance issues identified with how they're working. And naturally, most people going into a role, having been appointed through perhaps an extensive screening and recruitment process, it'll be the last thing on their mind. They'll be thinking, I'm here to perform, I will perform, the company's backed me to go into this role, why would anyone necessarily be thinking about exiting me?
But it's also natural to think too that eventually you want to move on. You won't want to stay in the same role forever. So, a lot of executive packages are tied to specific performances, and also when exiting, it's not necessarily as easy as just sort of exiting the door and then taking everything with you. You've a lag time of 6 to 12 months sometimes.
Well, that's right. I mean, certainly on the remuneration side, significant portions of remuneration are going to be linked to the service. Sometimes long-term incentive schemes will automatically drop away if you leave within a certain period of time, and certainly if you're dismissed for reasons of misconduct, for example. And the other issue that's very relevant here is, and just as importantly in the context of negotiations, is the issue of post-employment activity and restraints. So it's one thing to get your remuneration sorted out in a termination period by way of notice or severance, but just as importantly, what are going to be the restrictions that are put on you by your employer after the time that you might leave, whether it's of your own volition or the employer's.
And you're talking about things like anti-compete clauses.
Correct. A really significantly developing area, particularly in New South Wales, but right across Australia. And what we have seen in a number of states is a willingness of the courts to say, you might think that these things aren't worth the paper they're written on, but we are here to enforce them. And particularly if you've received valuable consideration and reward for having worked with an organisation, you've been exposed to confidential information, and you would be a risk to that employer if you worked for a competing organisation, the courts will uphold some non-compete and certainly non-solicit type arrangements in those contracts.
And how concerning is that? There are also issues of not being able to take, specific clients with you. What sort of damage does that do to an individual's career?
Well, again, all the more reason to try to turn your mind to those things up front, because they're not going to be things that employers are likely to budge on if you are going to go to a competitor, because you will most certainly be persona non grata and the employer will not be inclined to look after you. To the point about the damage it can do to your career, a lot of people's service and personal brand is very much hinged off the clients and customers that they have had relationships with, many of whom they would be looking to bring into the organisation. Indeed, that's probably why they've been hired in many instances. And so what we're seeing a lot at the moment is some individuals say, I brought all of these clients in, they're all my long-standing contacts, and my employer is now saying that even though I brought them in, they stay with my former employer and I can't take them to my next employer for a certain period of time. All of those kinds of things are capable of being being negotiated and should be negotiated up front.
Well, how do you negotiate those? Because, as you say, most large organisations won't budge on those kinds of issues.
Well, they're likely to budge more if they're going to budge at the front end of negotiations when they know that it's not a done deal to have the services of the executive locked in. Where they're highly unlikely to budge is if you ask for that movement at the time that you've communicated that you're going to go, or the employer might have a suspicion that you're going to go to a competitor. So the way you negotiate is at the time that a contract is presented to you, you indicate, presumably get some legal advice or advice from someone who's well versed in these matters.
Well, that's something I was going to ask you. Should individuals in this situation hire their own legal counsel?
Well, as a workplace lawyer, I've clearly got a vested interest in the answer to that question being yes. But I think what we're seeing is that there's so much more movement, there's so many more terminations of employment these days that employment lawyers are being kept a lot busier than what they might have been 10, 15 years ago. The front-end activity is getting those contracts negotiated well, and if it doesn't have to necessarily be a massive confrontation, it can just be about some tweaking of the clauses, but it can be invaluable when it comes to the pointy end of the relationship.
Now, we've been talking about what employees should do in terms of negotiation of their contract, but what the corollary to that, what should employers also be looking specifically at?
Absolutely, and the vast majority of our services are provided to employers. And again, what it comes down to for the employer is the issue of precedent, because the challenge for employers is that if you start deviating from your template employment contract every time someone asks for a change, then you're potentially looking at hundreds of different contracts that exist within your organisation. It's not sending a message of consistency and setting some ground rules and principles from an organisational point of view. Balanced against that is if you want to hold too firm on that line, you run the risk of alienating who could potentially be a very good candidate and worth a lot of money and kudos for your organisation. So that's the core of the challenge from an employer's point of view. These issues around restraints and remuneration are all things that they must look at, not just from the perspective of the individual employee, but also from the perspective of the message that they're sending to the whole organisation. And as much as they might think that it'll just be a confidential arrangement, word gets out. We all know that people talk, and that can often create a serious problem for the employer in the future.
Joydeep Hor, thanks for joining the program.
Pleasure.
As the big providers roll out their 4G networks for business, the digital superhighway is fast becoming a reality, with the prospect of doctors diagnosing